Hearing in the appeals in the matter of an application by Deborah McGuinness for judicial review.
Thank you. Well, I should say, Mr. Attorney, that we have decided that we will obviously hear you on the question of jurisdiction. We will then hear all of the other parties on both jurisdiction and the substance of the matter, because that's going to be the quickest way of resolving things if we find that we do have jurisdiction. Obviously, it'll be some wasted effort if we find that we don't, but we think we're grateful to you for timetabling it so that we can complete the hearing on both matters today. So thank you all.
I'm very grateful, Lady. My Lords, as you know, I appear on this historical survival jurisdictional issue, if I can so characterise it. My learned friend Mr. Schofield appears with Mr. McConkie for Mr. Stone. My learned friend Mrs. Merhan and Mr. McCleave appear for the department. My learned friend Mr. Lavery appears with Mr. O'Brien for Ms. McGuinness, and my learned friends Mr. Cole and Mr. McAteer appear for the commissioners. But then I hazard that the court already knows who everyone is. This is, as I've indicated, something of an historical survival. The forms of action we have buried, said Maitland, but they still rule us from their graves. And one would give a good deal to have Maitland's views on the rather odd arrangements that persist for appeals from the High Court in certain cases. And if putting what is an anomaly right will be ultimately a matter for the legislature, I hope that the analysis that we offer will at least make the determination of whether in the future something is a criminal cause or matter a little easier. And in arguing that there is no direct appeal in this case from the High Court to this court, it will, I hope, be very clear that there isn't the least suggestion that Mr. Stone and the department are without appeal rights. They do indeed possess appeal rights, but to the Court of Appeal in Northern Ireland. And that goes equally for Ms. McGuinness had the decision gone against her at first instance.
So what's the route of appeal to the Court of Appeal of Northern Ireland?
If it's not, and this is a point grasped, I say with respect, correctly by Mr. Stone's advisors, if this is not a criminal cause or matter, and it's not, there is no middle ground, and therefore appeal lies in the usual way under Section 35. Because at the core of the anomaly in this case is the shutting out by Section 35 of the Judicial Act, and that's at Supplementary Memory Stick 17, and the shutting out of a right of appeal normally enjoyed by all parties to judicial review proceedings.
Mr. Attorney, are there hard copies of the supplementary bundle?
I very much hope that's the law.
I think it may be. It may be volume. I think it may be volume 4.
This is.
Yes, I understand that they were.
Is this Additional Authorities Volume 4?
That's right. That's
If so, I apologise for taking your time up.
Not at all, my lord. Usually, and I say this with some boldness in the absence of Lord Kerr, who is, of course, sort of technically terribly adept, much more technically adept than I am. I'm more Stone Age in relation to my reliance on paper, but I always assume that the court is much more technically advanced than I am. So that is at Supplementary Memory Stick 17. There is the general conferral in Section 35.1. and
I'm not sure that it is. But I don't want to waste time on it. If we've got it in hard copy, that's fine. But I don't think I've got something which is that paginated in that way.
I think it's tab 50 in
Yes.
on
Yeah.
4.
It
and
is,
It's MS.
But I
It's
don't
marked
think we've got it
MS 17.
electronically.
Sub MS 17.
there are two. There is a general memory stick for the great bulk of the materials, and there is a supplementary memory stick. This is supplementary memory stick.
Well, I understand that. I've got 3 tabs on my machine, one of which is your case, one of which is the intervener's documents, and one of which is the main appeal documents. So I thought it might be in the intervener's documents, but that wouldn't give me the right sort of page reference.
It gives you page 17. This gives me page 17. I think so.
Let's see if we can find that. But worry not, we've got it here. So.
All right, I'm grateful, my lady. So there is a general conferral of a right to appeal in section 35(1), and in section 35, subsection 2, no appeal to the Court of Appeal shall lie, except as provided by the following provisions of this part, from any judgment of the High Court in any criminal cause or matter. So, in many ways, that's the anomaly, and our position is that if a particular case isn't a criminal cause or matter, then the usual appeal right to the Court of Appeal lies in the path of any party wishing to have recourse against first instance proceedings. And the approach to interpretation of section 35 and in due course section 41 of this Act isn't about either a generous or niggardly approach to interpretation. It's about using all of the available statutory tools. And section 41 subsection 6, and that's a little further on in that bundle, at supplementary memory stick 21, seems only to have been discussed in one Northern Ireland case, Coney, and they're wrongly applied, we respectfully say, and we'll look at that in due course. And the equivalent of section 41(6) of the Judicial Act is section 17 of the Administration of Justice Act. And that is in the same bundle, and it should be just after the page 12 of that same bundle. So if the court would just look at that briefly. We'll find that it is in materially identical terms to the section 41(6).
Which section are we on now?
We're looking first at the Administration of Justice Act, section 17, which is at a supplementary memory stick page 12, section 17(1), A to C. And I ask the court to compare that with section 41(6), which is at memory stick, supplementary memory stick 21. Now, perhaps strikingly, it doesn't appear that section 17(1), according to the best of our electronic searches has been discussed or cited in any case dealing with this issue. Indeed, the only reference to Section 17 at all seems to be in the case of Gelberg, and that's right at the end of this bundle. Supplementary memory, page 262, going on to 263. Section 17, subsection 4 is cited. But that's it. There is no discussion of the effect of Section 17.1. As we say, there is one case in Northern Ireland which looks briefly, fleetingly, and we say with respect wrongly, at Section 41.6, but that's it.
Yeah, Section 17 of the 1960 Act is an interpretation provision.
It is.
And that's interpretation with reference to what substantive provision?
It's in Section 1, which is a little further back. It's the right of appeal at memory stick, supplementary memory stick, page 9, my lord.
Yes, thank you.
Now, it's no part of my task this morning to argue the substance of the matter that was before the divisional court, but for the purpose of setting some context for the argument on jurisdiction, I do want to ask the court to look at the decision taken by the Department of Justice that was then challenged by Ms. McGuinness. And I'd ask the court to look, before looking at the judgment, to look in the appendix at the case management note by the learned judge at MS 315.
So is this in the main bundle?
It is. This is in the appendix, and it's MS 315. And paragraph 1, the learned judge says that there's a narrow, uncluttered issue. It's whether Mr. Stone has served the judicially imposed tariff of 30 years. The sole question for this court is whether this calculation is vitiated by illegality. And the notice of motion is at page 313, following the grant of leave by the learned judge. And then one has the judgment.
Mr. Attorney, if we're looking at 315, I slightly got the impression this was a draft order, because I turned over to 317, and at least I could find the identity of the judge who made the order and a date. And all these provisions that you're referring to on 315 and 316 get shipped into a proper order, don't they?
Yes, they do.
Yep, very well.
And then I'd ask the court to look at the judgment and the beginning in terms of the issues set out by the learned judge at paragraph 5P of his judgment. That's MS page 243. And this is the last item in the chronology that the court produces. And then by letter dated 20th of September 2017, the Prison Service, in effect the department, made a formal statutory referral of the prisoner's case to the parole commissioners, intimating that the tariff expiry date would be the 21st of March 2018. If one goes a little ahead in the judgment, one sees that the learned judge, the court, has helpfully set out some of the relevant provisions. Can I ask the court to note at MS page 251, Article 6.4 of the life sentence order, the Commissioner shall not give a direction under paragraph 3 with respect to a life prisoner to whom this paragraph applies unless A, the Department of Justice has referred the prisoner's case to the Commissioners, and then the role of the Commissioners in terms of being satisfied or not about whether or not the public need to be protected from him. And then finally in the judgment, the final order that the court makes is found at MS page 271. That's an order of certiorari removing to the High Court and quashing the decision of the Department of Justice, the respondent, to formally refer the case of the prisoner Michael Stone to the Parole Commissioners pursuant to Article 6 of the Life Sentences Northern Ireland Order 2001. So what one can take from that, I suggest, is there is discrete statutory function by the department, and that is at the core of Ms. McGuinness's challenge, and it's the core of the court's determination below. As the court will have seen from paragraph 7 of our printed case, supplementary memory stick 376, two main submissions are offered here. The first, in summary and without reference to section 41.6 of the Judicature Northern Ireland Act 1978, is that the challenge to Ms. McGuinness to the determination of the department under Article 6 of the 2001 order is not a criminal cause or matter. And for that submission, two propositions are advanced. The first is that cases such as McAtee, and one finds McAtee in relevant part at supplementary memory stick page 85 and 86, proceed on the basis that there is a distinction between challenges to the sentence, which are a criminal cause or matter, and challenges to the administration of the sentence, which are not. So in supplementary memory stick page 85, the second sentence in paragraph 43, we agree with Ms. Callan that the fact that Mr. McAtee seeks a declaration of incompatibility cannot of itself mean that this case is not a criminal cause or matter. That would be a triumph of form over substance. The reality is that he is seeking a declaration because his aim is that if the claim succeeds, it may thereafter result in alteration to the licence provisions to which he is currently subject.
What was the actual subject matter of the case?
The licence requirement under the then applicable sentence regime, it was a 10-year licence period. Now, we have 2 points about that. The court will have seen from our printed case that we say, if it is indeed a challenge to the sentence, then that's a reason why the High Court shouldn't have entertained it, because that is in effect a challenge to an order of the Crown Court, and therefore inapt for judicial review. But the second submission is that actually in this area, where Section 17 of the Administration of Justice Act applies, form is pretty important, because setting aside an issue which I know has been floated from time to time about the extent to which Section 4 of the Human Rights Act confers a cause of action, if one looks back at Section 17, at memory stick page 12, one sees that the nature of the application does indeed matter very much. So it's in relation to proceedings for an offence, and in relation to an applicant for an order of mandamus, prohibition or certiorari in connection with such proceedings. So if one is simply seeking declaratory relief, that isn't within Section 17, nor is it within, as we've seen, Section 41(6) of the Judicial Act. And I'm quite sure that had the court been addressed on Section 17, it would at least have said something about it. But the perhaps slightly surprising point is that in none of these cases does Section 17 appear to have been drawn to the court's attention.
But I'm sorry, you're saying that the references to mandamus, prohibition, certiorari don't extend to a declaration, even though it's in having exactly the same effect. And that's presumably simply because the 1960 Act was passed long before the modern development of judicial review.
The 1978 Act was quite pioneering and make express provision in primary legislation elsewhere for judicial review, but it's remarkable that still in Section 41(6) it uses prohibition, certiorari, mandamus. Now, I suggest, and I'll develop this point, there's actually an important reason for that, because the primary focus of the type of criminal causes or matters are courts of inferior jurisdiction. And when one thinks about the historic use of prohibition, it is traditionally to refrain someone, a body, a judge, a court, from exceeding his or its jurisdiction. So it's helpful in giving colour to what we say is its necessary interpretive effect. But, and it may be ultimately unsatisfactory in a policy sense, but the form does matter. The nature of the application matters profoundly for the purpose of Section 17 and for Section 41(6).
For my part, I find that slightly surprising because this section was drafted at a time when one had the prerogative writs, and so it uses that language. But you're saying that it can't be interpreted as applying to a modern judicial review proceeding?
No, because again, the Northern Ireland Act, which in the same Act provides what is still the statutory basis for judicial review in Northern Ireland, uses materially identical language. But that's, in essence, a secondary point in relation to McAtee. The big point about McAtee is that McAtee shows the distinction, we say, between a straight head-on challenge to a sentence, and which McAtee was, and a calculation, an administrative exercise in relation to a sentence. And one sees that in the commentary of the court in paragraph 52 at supplementary memory stick page 86.
Basically, the challenge was to the compatibility of the indefinite sentence for public protection requirements with the Human Rights Act.
Yes.
And you say that is a challenge to the sentence, the legality of the sentence itself.
Yes. And of course, let me not for a moment be heard to say that there was no way in which that point couldn't have been taken. It could have been taken, of course, in an appeal against sentence and a declaration of incompatibility being sought in the context of an appeal to the Court of Appeal Criminal Division in which that issue could be raised. But precisely because it was, in essence, a challenge to the sentence, it was in essence, a challenge to the order of the learned Crown Court judge, and therefore impermissible by way of judicial review. And one has the initial point that the nature of the application sought to be shoehorned into Section 4 of the Human Rights Act, meant that it fell out with Section 17 of the Administrative Justice Act. The second,
You say the Court of Appeal was wrong, but they hadn't had it drawn to their attention.
yes, respectfully so. And the second proposition that we advance in relation to this first submission is that the analysis of the divisional court in McGuinness number 3 supports a conclusion that the classification by the divisional court in this case, that these were proceedings in a criminal cause or matter were wrong. And we develop that further in paragraph 10 of our printed case, supplementary memory stick 377, and draw attention to paragraphs 38, 39, 40 and 45 of the judgment in McGuinness number 3, and that's at supplementary memory stick 133 going on to 134. So can I turn to our second submission? The fact that appeals in criminal causes or matters heard by the High Court don't lie to the Court of Appeal, but lie instead to the Supreme Court and formerly lay to the House of Lords, is the surviving remnant of two things, two old features of the Pre-Judicature Act legal landscape. The first is the historic availability of a writ of error from the limited criminal jurisdiction of the Court of Queen's Bench in Ireland to the House of Lords that was retained by section 65 of the Judicature Ireland Act 1877, and that's supplementary memory stick 8. And one will look in vain, I think, in the English 1873 Act for an equivalent to this. It's introduced later in other ways because, of course, the plan in 1873 was to abolish appeals and writs of error to the House of Lords. But by the time a Judicature Act had been enacted for Ireland, that had been reversed, hence section 65. And of course, one can think simply from memory of cases that came that way. The famous case on marriage, the Queen against Millis, came by writ of error from the criminal jurisdiction of Queen's Bench in Ireland, and famously also Daniel O'Connell was convicted of misdemeanour by the Court of Queen's Bench and appealed successfully by writ of error, and that was the last occasion on which famously lay peers attempted to sit with the law lords.
But they were ignored, I think.
They were indeed. So the section 41.1 is, at least in part, the surviving remnant of the writ of error to the House of Lords that was preserved by section 65. And in terms of then the bar on appeals that we find in section 35, that's contained in section 50, which is at memory stick 7, and its point which needs to be made in relation to the expression criminal cause or matter, because it's found in the Judicature Act, one need only look at a provision like section 50 to see that the Judicature Act comfortably, or should I say uncomfortably, predates the era of precision drafting. A provision would not be drafted like that, and wouldn't have been drafted even in the early 20th century along those lines, because it's only really at the end, or close to the end of section 50, that one realises that there is, in fact, not quite a general and absolute bar on criminal matters going to the Court of Appeal. The door is left open for those in which there is a manifest error appearing on the record, but that essentially was strangled at birth, and the position very quickly became, as it is now in Section 35, that criminal causes or matters, cases so regarded, don't go to the Court of Appeal. So Section 35 is the surviving remnant of Section 50 of the 1877 Act, and Section 41(1) is the survivor of Section 65. Can I make two preliminary observations? The High Court in Northern Ireland no longer possesses any vestige of original criminal jurisdiction. The Crown Court has exclusive jurisdiction in relation to trials and indictment. And two, the bar on appeal rights to the Court of Appeal in what might be regarded as a criminal cause or matter is now to be regarded as anomalous. There is no policy justification for it. So can I look at what might be regarded as the existing orthodoxy? And one sees that best, I suggest, in JR 27. Can I ask the court to look at JR 27, beginning with the discussion of criminal cause or matter at MS 1028.
Is this?
This is general. This is reassuring. Memory stick. This is not our memory stick. So I trust your leadership will have this.
So you said 128. Did you say?
Yes, 1028.
1028. Thank you.
And the section 3 of the judgment contains with the statutory framework. And
what was the issue?
The issue in this case was whether the retention of samples by the police amounted to a criminal cause or matter. The tricky issue in trying to increase one's concrete understanding of the case is that it's clear that the DPP indicated that there would not be proceedings, but we don't know if the applicant in that case was ever charged. He was certainly arrested, samples were taken, but we don't know if he was ever charged. Put that another way, was there a prosecutor in that case? Was he ever a defendant? And the court looks at this in very considerable detail. So I commend to the court paragraphs 11 to 19. I draw attention to only one matter.
So which court is this? I think we've said it. Which court is this?
This is the divisional court.
The Northern Ireland Divisional Court.
It is, yes.
Where do we go next?
And I invite the court to look at paragraphs 11 to 19, but to note one thing, that in what is a very extensive canvassing of the materials, including some historical material, the court does not look at section 41, subsection 6. It's the missing piece of the jigsaw, and as we submit, it's a particularly important piece, not to be considered. Can I ask the court to look also, having read paragraphs 11 to 19 for itself, to look at what the Lord Chief Justice says, concluding his dissent at 1046.
So who were the majority?
Majority were Lord Justice McCluskey, as he now is, and Lord Justice Weatherup, as he then was, though I see he's down as Weatherup J, and the Lord Chief Justice dissented. And one sees
And you want us to look at,
I do, simply because of the cri de coeur in paragraph 50.
Can we take this by stages? 11 to 19. You want
11 to
look at?
19, so the court will read...
Oh, well, can you let us do that, and then we can perhaps go from there? Sorry.
yes,
And then, very briefly, just the cri de coeur of the Lord Chief Justice in paragraph 50, MS page 1046. As is apparent from the numerous authorities referred to in the judgments, in this case, the procedural issue has occupied a considerable amount of court time. The practical effect of the determination that an application is a criminal cause or matter is that the only appeal right available to the applicant requires certification that a point of law of general public importance is involved, as well as in the court of first instance. In this jurisdiction, there is no reason to believe that the provision of a right of appeal to the Court of Appeal in such cases would significantly increase the workload of the court. The requirement to appeal directly to the Supreme Court now seems anomalous. And I emphasise that an aspect of this submission will be to provide a tool for courts which may the more readily determine whether or not a matter is a criminal cause or matter.
what's the position in relation to extradition in Northern Ireland?
Extradition will be a criminal cause or matter.
It's always regarded as a
It is.
criminal cause or matter. Yeah.
But
Despite the fact that there are no extant criminal proceedings in this country.
well, there are proceedings for an offence, but not here.
But not here.
So and can I ask the court to look very briefly at Belhaj? Obviously, 3 members of this panel participated in that decision. So,
But I think I'm outnumbered on this occasion.
well, that thought, I must confess, hadn't occurred to me, my lady, but of course your ladyship is entirely correct. But well, we'll see what comes of that. Can I ask the court to look at supplementary MS page 223, paragraph 17, and the judgment of Lord Sumption, with which my Lady Hale agrees. And I draw attention to this simply because, again, it contains a useful statement of the historical position. But I ask the court to note something which is perhaps of some significance. In section 151 of the Senior Courts Act, clear definitions are given. So cause means any action or any criminal proceedings, and matter means any proceedings in court, not on a cause. Can I ask the court simply to note, I won't take the court to it right now, but that in section 121 of the Judicial Act, the definitions are not framed quite that way. They are cause includes, and then similar words, matter includes. So there is no reason why, in a sense, that the cause or matter in our context need not actually fold over. And I emphasise this phrase antedates precision drafting. And again, I speak with diffidence in the presence of three members of the panel in Belhaj, but it doesn't appear to me, certainly from the report, that there was any citation to the court of section 17 of the Administration of Justice Act. And
do you have the bundle reference for section 121 of the Judicial Act that you just read?
I do. It is section, I'm sorry, my lord, it's section 120, and it's at MS, supplementary MS 27.
Thank you.
And matter is found on supplementary MS page 28, cause on 27, matter overleaf. So it doesn't appear that section 17 of the 1960 Act was cited or discussed. And of course, the discussion of criminal cause or matter took place at an additional tier because it was in relation to the closed proceeding effect of that phrase, rather than the nature of the underlying proceedings, primarily at least. But that was a case in which, ex hypothesi, there was no prosecutor and no defendant. And therefore it's difficult to see how the case ended up in this court. Because in section 1 of the Administration of Justice Act, at supplementary memory stick page 9, an appeal shall lie to the Supreme Court at the instance of the defendant or the prosecutor. The applicant very much hoped that there would be a prosecutor and that there would be a defendant, but neither were in fact present.
So you're saying that they got it wrong in Belhaj?
Well, the point wasn't taken, and neither section 1 nor section 17, and I speak with diffidence, obviously, in the presence of three members of the panel in that case.
You can say whatever you like as long as you say it politely.
As I wasn't there, so
Now, I don't recall, and I'm sure that my fellow justices on the case don't recall that any point was taken about section 1 and section 17 of the 1960 Act.
Well, can we look a little more closely then at section 41(1), and we have it at supplementary memory stick page 21. And there is no sense when one looks at section 41(1) that anyone is being excluded. An appeal right is being conferred in terms which are on their face general. There is obviously a prosecutor and a defendant in case-stated proceedings. They are, after all, proceedings for an offence. And similarly, there is no sense that any criminal cause or matter proceedings are being excluded, and we say that it makes sense to view the conferral of appeal rights as embracing all of the relevant subject area of criminal cause or matter. That proceedings in a criminal cause or matter must have a prosecutor and a defendant to amount to a criminal cause or matter seems necessary, and it helps to identify what a criminal cause or matter is and whether any particular case is a criminal cause or matter. And in particular, when one looks at section 41, subsection 6, A1, there must be a defendant as defined by that provision in the proceedings for an offence, and for the prohibition, certiorari, or mandamus provisions in connection with the proceedings for an offence. And it does matter, we say, what is sought in the application. An application for a declaration doesn't come within section 41(6)(a)(1) or section 17 of the Administration of Justice Act. And one can go further, I submit. The prosecutor is not there as an ornament or as a fiction to confer jurisdiction. The decision connected to the proceedings for an offence must be a decision in which the prosecutor has an interest. So, the judicial review proceedings, to use that shorthand, but in fact not all judicial review proceedings are caught by section 41(6)(a)(1). They need not merely be, in fact it's not sufficient that they be connected to an offence. They must be in connection with proceedings for an offence. And that is a limiting condition, and the result is that connected with proceedings for an offence, the language of section 41(6)(a) is a narrower category than being connected with the offence. And that has consequences for this case. Firstly, bearing in mind the immunity of the Crown Court in Northern Ireland to judicial review, the Crown Court being, of course, part of the Court of Judicature, section 41(6)(a)(1) does not refer to decisions of the Crown Court itself in proceedings for an offence, because they cannot be subject to mandamus, prohibition, or certiorari. For an example of the kind of decision that is caught is the decision, for example, of the prosecutor in the Crown Court, for example, in the Hutchings case. And that is at supplementary memory stick 92-93, where it sees the nature of the decision taken there. Secondly, the life sentence imposed on Mr. Stone is, of course, the causa sine qua non of our presence here this morning. But that sentence couldn't, of course, be challenged by judicial review, and aspects of its administration can be challenged precisely and only to the extent that they are distant from and unconnected with the unassailable order of the Crown Court, that is, unassailable by judicial review. Let me comment briefly on some aspects of the department's case and Mr. Stone's case. Firstly, the department rely on the residual category of definition of defendant in section 120, and that is misplaced. That definition cannot apply, whereas here specific provision is made for the term in section 41(6)(a)(1, and when defendant is used to identify the nature of the very proceedings. Secondly, the case of decision in Coney has, with respect, led the department astray, and I'll ask the court now to look at Coney. Coney begins at supplementary memory stick page 257. I'd ask the court to look at paragraph 7 at supplementary memory stick page 258. And section 41 is headed Appeals to Supreme Court, formerly the House of Lords, in other criminal matters. The reference to other criminal matters seems to relate to matters which were out with those dealt with, and then there's a reference to section 40, now repealed, of the Judicature Act, which dealt with appeals against conviction or sentence from the Crown Court. But I simply ask the court just to note, en passant, the use of matters to embrace the concept of criminal cause or matter. And our submission, short submission, is really there's no magic in the phrase. And then when the learned judge sets out section 41 and the submissions, and then he says this at paragraph 14. While the court appreciates that it may be said, as the respondent has said, that a bail application is not in itself in the nature of proceedings for an offence, the language of subsection 6A1 is that any reference to the defendant shall be construed in relation to proceedings for an offence as a reference to the person who was in those proceedings or would have been the defendant. It seems to the court that a bail application is an application in relation to proceedings for an offence, even though it does not itself constitute proceedings for an offence. Now, with respect, that is an egregious error. What the judge has done by that is introduce a new element into section 41.6, that it doesn't matter if they're not proceedings for an offence, as long as one is in some way related to proceedings for an offence. But that is to entirely misunderstand the nature of what is being done by section 41.6, where the purpose is to identify who is the defendant and who the prosecutor. So it's any reference to the defendant shall be construed, one, in relation to proceedings for an offence. That introduces the notion of who will be the defendant in those circumstances. It does not expand the nature of the first clause in that provision. It's a profound, one says with respect, misreading of that provision. And the department say in paragraph 27 of its case, supplementary memory stick page 393, that this is a head-on challenge to the sentence. It's not really about administration or sentence calculation, but we say that is exploded with respect when one looks at the analysis that the divisional court itself gave to the particular issue that it resolved. Finally, in relation to Mr. Stone's case, Mr. Stone brandishes Belhaj at me and says, well, what I'm saying is inconsistent with that. What I say is, no, it's not on the facts, different set of circumstances, but in any event, of course, neither Section 1 nor Section 17 of the 1960 Act were discussed in that case. We're also criticised for criticising McAtee only in relation to the Crown Court jurisdiction point, but the court will recall that we also raised the issue that the nature of the proceedings in McAtee, as one can glean from the judgment, fell out with those identified in Section 17.
Mr. Attorney, I'm sure it's entirely my fault, but you've taken considerable issue with the judgment in Reconi. Can you just rewind and repeat where you submit Mr. Justice Maguire went wrong?
Well, I will attempt to, my lord. Can I ask the court to look again at the section 41 as the learned judge set it out, supplementary memory stick, page 258 to 259. And if one looks at 6, which is on supplementary memory stick 259, in this section, and sections 44, 45 and Schedule 1, any reference to the defendant shall be construed, Roman 1, in relation to proceedings for an offence, and so on.
Can I just interrupt you to put your argument as I have understood it, and then you can tell me if I'm wrong, and this may be of assistance to both of us.
Thank you.
I think what you are saying is that section 41, subsection 1, provides that an appeal shall lie to the Supreme Court at the instance of the defendant or the prosecutor, A, from any decision of the High Court in a criminal cause or matter. It doesn't say in relation to a criminal cause or matter, it just says in a criminal cause or matter. Subsection 6, of course, says a reference to the defendant shall be construed in relation to proceedings for an offence, etc. But you say that doesn't introduce in relation to into subsection 1. It is simply saying what the definition refers to.
Yes. And I'm enormously grateful, lady.
So am I. Thank you.
And one cannot reinforce it, I hope, when one goes down the other categories, Roman 2 and Roman 3. So in relation to any proceedings or order in respect of contempt of court. So that's when you're dealing with contempt of court proceedings. It doesn't mean when you're dealing with something that is penumbral to contempt of court proceedings, and likewise for habeas corpus. My lords,
That's about spot on time.
Bang on time.
Yes.
Those are my submissions.
Thank you very much indeed, Mr. Attorney. Yes, Ms. Monaghan.
Good morning, my lady, my lords. On behalf of the defendant, I hope to make these submissions as economically as possible. I'm bearing in mind the fact that the court has our detailed written submissions on 2 issues in play. I'd like to outline what I intend to speak about this morning, and I'd like to identify those issues and then move on to them, if I may. I would firstly propose to deal with the jurisdictional issue raised by the Attorney General for Northern Ireland, and then secondly, I'll hope to move on to the substance of this appeal. In respect of the jurisdictional issue, I wish to firstly outline the basis on which the defendant contends that this challenge was properly a criminal cause or matter, and then secondly, I will have some comments to make as to why it is that we say that the Department has standing under Section 41 of the 1978 Act to bring this appeal. In terms of the substance of the remarks I want to make in the substance of the appeal, there are 4 headline points I'd like to make in respect of those. And those are in my route map, roughly sketched out as starting with the Good Friday Agreement as the genesis for the Northern Ireland Sentences Act, which I'll refer to as the 98 Act. And secondly, then I'll move on to its interaction with the Life Sentences Northern Ireland Order, which again I hope it's convenient to refer to as the 2001 Order. And then thirdly, I'll want to try and explain why it is that we say that the net question in this case, which is ultimately whether those 6+ years that Mr. Stone spent on licence pursuant to the 98 Order should be counted in the calculation of his tariff as imposed under the 2001 Order. Then, fourthly, I just will have some very brief submissions to make in respect of the Divisional Court's decision. So, moving then back to this jurisdictional issue, our primary submission is that the judicial review application, the subject matter of these appeals, was correctly determined as a criminal cause or matter. And we say this for a number of reasons. And firstly, we take a different view to the attorney in respect of the factual matrix We say, in fact, that the factual matrix which the attorney took us to at subparagraph P, in fact, was just that. It was the factual matrix in that case. And perhaps the better substance of what this case involved was articulated by the Divisional Court in paragraph 20 of that decision. So perhaps we could turn to that. That's at the core volume, page MS 256. And that has been identified at the very bottom of 256 in paragraph 20 as being the central issue is whether Mr. Stone's period of licensed release of some 6 years under the 98 Act should be included in his judicially determined tariff. And then if we move on down a little bit, the resolution of this issue is not to be found in the express provisions of either the 98 Act or the 2001 order. In the ideal world, the legislature would have made provision for this eventuality lying at the heart of these proceedings. The reality is that it did not do so. The court is therefore driven to filling the resulting void. And we say that that is really what is at issue in this case, rather than, with respect, the list of that has been referred to of the factual matrix that commences at page 241. We say that the referral on to the parole commissioners was really a collateral consequence of the issue that was truly under consideration before the court. We also then say that having identified what this case was about before the Divisional Court, we say that stepping aside from that, the phrase a criminal cause or matter should be afforded the widest possible interpretation, and we trace the long line of this type of approach, this type of expansive approach from Lord Esher's dicta in Woodhall, and we say to that effect that a criminal cause or matter can be applied to any decision by way of judicial review if on any question in any proceedings, if that subject matter is connected to proceedings which are criminal. And we specifically say that a narrow interpretation of cause or matter was confirmed by Lord Wright in the Armand case, but we draw particularly also on Lord Wright in Armand and what was articulated in the JOR 27 case as being the jeopardy principle. And the jeopardy principle, of course, will be familiar to this court from the decision, but and often the jeopardy principle looks towards a conclusion that will result in conviction. Obviously, in this instance, Mr. Stone could not be subject to any further conviction, but what he could, of course, as a result of this challenge, be subject to was an additional significant period of incarceration, and we say that that detriment or punishment should fulfil the jeopardy principle.
Is it an additional penalty, or is it simply loss of the relief arising from the supervening statute?
Well, I think it's the loss of the relief rather than, I wouldn't go so far as to put it as an additional penalty. We say that the relief that was offered by the 98 Act, when I will deal with that in more detail, was such that it was envisaged that any time spent on licence pursuant to the 98 Act would in fact then run down any judicially imposed tariff thereafter. And we say that with reference to a number of factors, most predominantly being the interpretation of Section 4 of that, but I'll return to that in more detail.
Did I mention the case I have in mind?
Yes.
Which is Queen and Governor of Brockhill Prison, ex parte Evans number 2. I don't know if you looked at that 2001 appeal cases. So that's the closest case I'm aware of in terms of what happened, where the prison governor miscalculated the release date of a prisoner. And that proceeded through the English courts by way of ordinary judicial review. Now, I think it's fair to say there wasn't a discussion about whether that was a criminal causal matter, but it seems to have been treated by the House of Lords, as it then was, as and by the English Court of Appeal, as a standard judicial review sort of situation.
Well, that, of course, it chimes with, there were a number of cases of local Northern Irish cases that we looked at that, of course, had at their heart the question of a release date of a dispute over the accuracy of a release date. Where we say this is different is that this really isn't to do with which is the appropriate release date. What this case is at its heart about is the sentencing regime and what is meant by the overlay of the 2001 order on the sentencing instrument that was introduced in a very extraordinary way by the 98 order, or 98 Act, and on that basis we say it's the interplay between those two pieces of legislation.
And you say that that is part of the definition of the sentence?
Yes.
Basically?
Yes.
So it is the identification of the legal components of the sentence?
Yes.
And so you say it's like McAtee?
Yes. Thank you very much for that. That's very helpful. That is our submissions. Certainly the way that we are trying to articulate them, and the fact that, so hopefully we have distinguished that it isn't just about a release date. The release date, of course, inexorably flows from what the correct sentencing regime or what the correct criminal sentence imposed on Mr. Stone was, as seen now from the changes that were wrought on Mr. Stone's sentence. And it is true, of course, that a considerable passage of time has passed since he was originally sentenced. But that passage of time, there's nothing in any of the jurisprudence that I was able to locate that says that the mere passage of time is sufficient to break the connection. And where that is important is that not only has there been a passage of time, but there have been very fundamental events that have been imposed on his sentence retrospectively, and those are to include the impact of the 98 Act on his sentence, and then the impact of the 2001 order, and then the ultimate setting of his tariff, which in fact wasn't set until 2013 by the Lord Chief Justice in Northern Ireland. So we say that when taking all of those factors into account, one can see that this is properly a matter about a criminal cause or matter, and we say that rather than trying to shoehorn this into a genre or subset of cases, which we say would fly in the face of the expression of the court in McAtee, where there should be careful individual appraisal given to each case, that we say that, and I can give you the reference to that on the individual appraisal point if that's useful for your note. That's in, I don't think we need to open that, but that's in volume 4, tab 57, MS page 84. So we say that consequent on this aspect of individual appraisal, this case should be, and again with respect to the submissions made by the Attorney General, this should be distinguished from the case of McGuinness number 3. McGuinness number 3 involved parties. It was in a different context, and it involved the application of a very different statutory mechanism. And for those reasons, we say that looking to McGuinness number 3 to provide the answer in this question as to whether it is a criminal cause or matter is not actually instructive. Then I'd like to move on to the second part of my first part, if that were, in dealing with the Section 41 argument raised. And I wonder, it does seem that the focus in Section 41 is on the nomenclature of the defendant. And to steal a phrase that we've heard, I think articulated in McAtee this morning, was that that would be a triumph of form over substance if we were to interpret Section 41 in such a restrictive way as to exclude from the provisions of the appeal right based on what the definition of a defendant was. So our basic submission in this is that this is a criminal cause or matter, and that in order to then unpack Section 41, is that we say, we make 2 points, that the interpretation commended to the court by the Attorney General certainly doesn't reflect the approach of the courts historically, and certainly doesn't seem to be in any way consonant with the more expansive approach to what the definition of a criminal cause or matter is. And perhaps then if we turn to Section 41, which is located at Volume 4 of the Additional Authorities, tab 50, and that's MS 21. So really the operative part of, or the most contentious part perhaps of Section 41 is the definition, the restrictive definition that attention's been drawn to, subsection 6, where the definition of defendant is set out, and it's set out that in relation to proceedings for an offence, and in relation then to, and we understand now this morning that the attorney's case is so restrictive that that doesn't even encompass all of judicial review type cases. Well, we say that actually that it's quite correct that this is a provision that has received very little judicial interpretation. The only interpretation that we were able to locate was the Coney decision of Mr. Justice Maguire. But he has taken quite a different approach to the interpretation of Section 41 and has said really that it shouldn't be read in this narrow, restrictive way. We say that there's nothing in Section 41 that defines how proximate the connection has to be between the proceedings, and we see then the manner in which Mr. Justice Maguire was able to connect the originating criminal proceedings with the subsequent application for bail in such a manner. And we would say that that is relevant then to a general approach that affords, stepping back from Section 41, Section 41 is clearly designed at affording appeal rights to parties in criminal causes or matters, be they defendants or prosecutors, and clearly the identification of the prosecutor is subsequent to the identification of, firstly, of who is the defendant. And it was with some interest that I noted that in the McAtee case, the Secretary of State for Justice was described as the defendant, and in the Bellage case, the DPP was described as the defendant. Again, which seems to sit rather oddly, but presumably the descriptors of both the Secretary of State for Justice and the DPP in those contexts was in relation to those judicial review proceedings. And I can give the court those page references if that's helpful. They are located at MS page 188, tab 62 of the fourth volume, and MS 77 at paragraph 10. So it could be, we could certainly be accused of straining the statutory language in attempting to define the department as the respondent to the judicial review as the prosecutor, but we say that to do so would be consonant with an expansive approach and to afford a general right of appeal. We then also then pray and aid the use of Section 120 of the 1978 Act, and we have read that in such a way that if the court would like to turn, that's just on page 27 from where we were in the fourth volume, to Section 120. And we see that Section 120 is a general interpretive provision that applies to the whole of the Act, and it is restricted only as far as it says in this Act unless the context otherwise requires. What we say to that is that there's nothing to be read in section 41 that implies that the context requires that it is to exclude the definition of section 120. And to do so, to read section 120 and section 41 compatibly and as being complementary would permit the resolution of this ambiguity of the otherwise restrictive reading of section 41.
Sorry, I'm not quite sure what you're saying. I mean, section 41 says that in this context, defendant shall be construed in a particular way.
Yes.
I mean, you can't, that surely excludes a general interpretation relating to the Act as a whole.
But what it says is in this section, it should be construed. It doesn't say, with respect, that this context requires it to be exclusively construed in this manner. And clearly, if it could be a strain, but if section 120 was read to be ancillary to or the provisions in section 41, unusual as it would be, it would at least permit another route to find that in matters which had properly been found to involve a criminal cause or matter, that it would afford parties a right to appeal, because I'm fairly sure that it's uncontroversial to state that it could not have been the legislature's intention to create a genre of judicial review cases that were properly found to involve a criminal cause or matter, but which did not have a right of appeal. That they were heard by the divisional court from simply the fact that there was no readily identifiable defendant or prosecutor.
But isn't it agreed that, I mean, if it isn't a criminal cause of matter, you can appeal to the Court of Appeal in Northern Ireland?
Of course, but...
so when you say there must be an appeal, and you must be right about that, there's got to be an appeal in relation to something like this, do we need to strain things? You've got an appeal either way.
We have an appeal either way, but I think perhaps the focus on excluding cases that are criminal causes or matters often relates to the rights of appeal. And there are, of course, two ways of looking at this, as the court will know. The advantage for the applicant in having it determined to be a criminal cause or matter in perhaps borderline cases is that rather than having a single High Court judge determine his appeal, he has the benefit of 2 or possibly 3 High Court judges. And we would say, therefore, an increased attention to his case, and perhaps with that an increased likelihood that his case will be correctly determined. Where it's perhaps less advantageous to him is that he doesn't have an automatic right of appeal to the Supreme Court. That could be seen as a disadvantage to the applicant, but certainly it could equally be seen as an advantage that rather than having to go through another appeal to the Court of Appeal, and then perhaps if that wasn't properly determined, on from there to the Supreme Court, the applicant gets direct access to the Supreme Court if there is a case, a matter that properly requires determination. So it can be seen in both ways. So I'm not suggesting that that cases that aren't properly criminal causes or matters, but it is an important protection, we say, for applicants, that if there is a determination that their case involves a criminal cause or matter, in line with the general swathe of jurisprudence, that then they from there have a right of appeal.
I mean, isn't it going to be a narrower right of appeal to the Supreme Court than to the Court of Appeal? Yes. Because the Court of Appeal will just apply the usual permission to appeal to the Court of Appeal requirement. So actually there's going to be a wider appeal right for a defendant or for the applicant, if it's not a criminal cause or matter, because it's going to be easier to go to the Court of Appeal.
That's entirely correct, but that is, of course, the way in which we understand the attorney's argument to be, that setting aside all of the decisions in Belhaj and McAtee, that criminal cause or matter should really be determined by the scope of parties who can fall within the narrow confines of Section 41, and that then will reduce the genre of cases that are determined to be criminal causes or matters. And in doing so, that would obviously chime with the views of the Lord Chief Justice of Northern Ireland in the JR 27 case, which the attorney brought us to this morning, wherein he deprecates the overuse, or what he sees as an unnecessarily expansive use of determinations that cases are divisional court cases. So there are clearly two schools of thought on this,
Yes.
and
We've grasped that.
yes. And not only are there two schools of thought, but what we would say is that we would like and encourage that all of the old cases. There's been considerable paper and print spent on analysing the history of the criminal cause or matter, but that everything now should be seen through the prism of the very recent visitation of this issue in the Belhaj decision. And we say that by the analysis of the Belhaj decision, that this case, as it came before this divisional court, was properly determined as being a criminal cause or matter. I may have spent sufficient time on this issue. It is a...
Well, others are going to get their say too.
Yes.
So you might as well move on to the substance.
Yes, I'm conscious of that, my lady. So to move on to the question of really what is substantive appeal at the heart of this case before the court, I briefly rehearsed the topics I'd wish to touch on, which are the Good Friday Agreement, moving then to the examination of the legislative framework, being the 98 Act, the 2001 Order, and trying to unpack this vexed question of how to treat the period of licensed release that was afforded to Mr. Stone, and indeed to many others in his situation, and then dealing with, finally, the Divisional Court's decision. So the reason why we say that this court should consider the Good Friday Agreement is because, as we all know, it made controversially at the time, and possibly still controversially, it made provision for an accelerated release programme for those prisoners who were convicted of scheduled offences. And the importance of this is that this was the direct stimulus for the speedy introduction within 3 months of the 98 Act. And the key point that we'd like to make in relation to the Good Friday Agreement is that nowhere expressed in that agreement, in the relevant section, was there any distinction made between the types of prisoners who would benefit from it. Rather, it was aimed at all qualifying prisoners. Perhaps to that end, we could turn to just look briefly at that. That's in Volume 1. Tab 22, page 1020, the MS pages. In fact, it's just at the very back of that hard copy. And I'd ask the court to look very briefly at paragraph 3. If we could pick that up in the middle, it's the commitment. Both governments will complete a review process within a fixed time frame and set prospective release dates for all qualifying prisoners. And we emphasise that it is all qualifying prisoners. The review process would provide for the advance of the release dates of qualifying prisoners while allowing account to be taken of the seriousness of the offences, and secondly also for which the person was convicted, and secondly the need to protect the community. So that it's a fairly wide and unspecific aim. It it certainly doesn't differentiate between the types of prisoners so long as they are determined as being qualifying. So the second point I'd like to make out of in relation to this provision in the Good Friday Agreement is that there's nowhere in it any articulation of the traditional concepts of retribution and deterrence that we'll then come on to see are relevant in our consideration of the 2001 order. We also think that our analysis of the Good Friday Agreement is supported by the extensive treatment that it received in the McLean decision, which, if I could ask the court to turn to, is at tab 10 of the same volume 1. And I ask the court to look at some of the comments of Lord Scott, which begin at page 666. And what he said, picking this up in the middle of paragraph 49, towards the bottom of that page, he says, the statutory scheme was introduced in the pursuit of a highly important political objective. It was not introduced in order to respond to any requirement of criminal justice or in recognition of human rights guaranteed by the Convention. Its wellspring was political, namely the political imperative of trying to move towards a political settlement in Northern Ireland. And of course, that chimes with the equally detailed analysis carried out by Lord Bingham earlier in the decision, where he found the scheme to be extraordinary. And we do say that it was an extraordinary scheme. Then, looking directly at the 98 Act, it's common case between all of the parties that Mr. Stone was found to be an eligible prisoner under Section 3, that he was duly released, having reached the terms of his licence. He was revoked under his licence was revoked under Section 8, and he was duly recalled under Section 9. But we suggest that an important aspect of the understanding of how that time that he spent while on licence should be treated can be illuminated by consideration of Section 4.4. In broad terms, Section 4 dealt with fixed-term prisoners, whereas Section 6 dealt with the life prisoners. And perhaps if we turn to the 98 Act, which is in tab 13, 745. Volume 1. Sorry, that's in the primary authorities, Volume 1. Draw particular emphasis to Section 4.4 because it concerns, that's at the bottom of, that's middle of page 743. The significance that we say that should be attributed to Section 4.4 is that the released prisoner, who in this provision is obviously a fixed-term prisoner, his licence can expire and the sentence can lapse during the period of his release. And the significance that we say that should be attributed to this provision is this, that clearly, whilst on release on licence under the 98 Act, he is running down the clock on the custodial element of his sentence. And in fact, not only is this generous provision permitting him to run down the clock on his sentence, we see that from the second limb of this, his sentence shall expire and the licence shall lapse at the time when he could have been discharged on the ground of good conduct under prison rules. So it doesn't expire at the end point of his sentence, but in those days the scheduled offences were subject to remission. So his liability for recall under the licence granted under the 98 Act ended at the point at which he would have been eligible for remission for good behaviour. Now, obviously, this needs to be contrasted with the provision at Section 6, where we candidly admit there is no similar provision for life prisoners, but the argument that we seek to counter that has been made by the respondent to these appeals is that, of course, there are differences in how fixed-term prisoners are treated. That is evident from a consideration of the additional condition that a life prisoner has to meet in Section 3(6), where he has to show that he will not be a danger to the public. And that is also mirrored in his licence condition, that he has an additional condition over and above that of the fixed-term prisoner, where he has to show that he will not become a danger to the public. Now, why there's a difference, a justification for the difference in the treatment of the life prisoner there, we say is relates back to the point that I took you to earlier in relation to the Good Friday Agreement, which was specific that account should be taken of the seriousness of the offences and the need to protect the community. So there is some justification in the Good Friday Agreement for the different treatment of the life prisoner at that point, where there is not in the Good Friday Agreement any justification for the difference on how the credit for the time that they spend on licence is to be considered should they, of course, breach and be returned to prison. So while there is justification for those differences, we say there's no justification for the conclusion that the Divisional Court reached in relation to Mr. Stone's case. We admit that there isn't an analogous provision in Section 6, which deals with the life sentence prisoner, to Section 4.4. But again, we say that's not surprising because there couldn't be because of the unavailability of remission for good behaviour in a life prison. And additionally, we couldn't have prospectively expected the draftsman to have anticipated the introduction of the 2001 order 3 years hence. So we say that an important aspect of how to approach the consideration of the credit that should be attributed to life prisoners should be interpreted in the same way as it's applied to fixed-term prisoners. And to that end, we also point to the similarity of language that is peppered throughout this Act in terms of how they both serve their sentence. And we would say that it's consonant with the idea of ensuring that there's a consistency of treatment between the two types of prisoners, because we say that it could not have been envisaged that the Good Friday Agreement would make such a significant difference in how the credit for time spent on licence would be applied to the different types of prisoners. The difficulty, of course, then emerges when we overlay the subsequent introduction of the 2001 order onto the existing 98 Act. And the first observation that we'd like to make in relation to that is that it's inconceivable, really, that the draftsman in Northern Ireland, some 3 years after, I think it was 149 life prisoners had been released on foot of the 98 Act, wouldn't have had an awareness that there was this significant cadre of life sentence prisoners who potentially could be impacted by the introduction of their 2001 order. And we also say it's uncontroversial, surely, to state that it would have been anticipated that there was going to be a coherent legislative scheme introduced. Now, the basis on which the 2001 order came into effect with Mr. Stone's sentence was when his licence was revoked under the 98 Act, and there was a subsequent setting of a life tariff for him by the Lord Chief Justice in Northern Ireland. And we say that consideration of the 2001 order drives us to an examination of an examination of the most significant provision, which we say is Article 6. And if I could ask the court to turn to, it should be at tab 14 of the hard copy, MS page 775. And Article 6, rather, sets out the duty to release certain life prisoners. What we say, would like to draw the court's attention to are three issues in this. The significance of what section or Article 6.6 means, the impact of this provision on the definition of part of their sentence, and then the concept of having served a sentence. So firstly, to deal then with Article 6.6. 6.6 at the bottom of page 775 provides that in determining for the purpose of this article whether a life prisoner has served the relevant part of his sentence, no account shall be taken of any time during which he was unlawfully at large unless the department otherwise directs. And this is important for two principal reasons. This is the only provision in either of these instruments that provides guidance as to what can or cannot be taken into account when considering the relevant part of the sentence. We also say that significance derives from the fact that the department is expressly entitled on foot of Article 6.6 to make a direction to provide that time spent unlawfully at large can be taken into account. And it's therefore assumed that this was the only guidance that the legislature felt was necessary at the time, and leads to a presumption perhaps that if specific provision was made that the time unlawfully spent outside of provision can be subtracted from one's tariff, then surely time that was lawfully spent on licence could equally be taken into account.
Can you help me as to the circumstances in which a person might be lawfully at large before the expiry of the tariff period? Well,
the circumstances we say that when you could be lawfully at large would be if in receipt of the extraordinary grant of a licence under the 98 Act. So presumably all of those life prisoners who are subject to the licence granted under the 98 Act are lawfully at large.
Thank you.
Oh yes, of course. Yes, Mr. Schofield has very kindly assisted me by reminding me, of course, there are also a number of schemes which the department runs in terms of pre-release home leave and rehabilitative release or compassionate temporary release when one could be lawfully at large.
Well, that was what I had in mind, but would those operate before the expiry of the tariff period? They would.
Sorry,
I missed Mr. Schofield nodding. My question.
Sorry, I missed the start of the question, my lord.
It was those matters that I had in mind.
Oh yes.
My question was whether those might operate before the expiry of the tariff period.
Yes, well, presumably they would, because if they are compassionate temporary release, that by their very definition, they would be perhaps released to attend a very ill relation, or if it was pre-release home leave for the purposes of rehabilitation into society. I'm certainly aware that there are a number of schemes which operate that take prisoners, life prisoners, outside of the prison for weekends to habituate themselves. So that we say is actually a significant impact of the Divisional Court's decision in this matter, because we say that it comes back to the point that we make in relation to the Learned Juniors very helpfully assisted that this is set out in our affidavit, which is found, I don't think we need to open it, but the detail of it is set out in the core volume at pages 364 to 66.
Thank you.
Thank you very much. The relevance of these lawful release schemes, of course, if these are by extension of the decision reached by the Divisional Court applied in equal measure, they could operate to be subtracted from the set tariff that has to be served, and that, we say, would impact on the certainty of individual prisoners and knowing how long they have to serve, and the prison then would be engaged in a rolling programme of recalculating sentence relief. And one could certainly see how it would be inimical to the idea that one would release prisoners early to rehabilitate them if they thought, well, ultimately I'm going to spend a longer period in prison, because they'd benefited from weekends leave, then their ultimate release date would have been pushed back further and further. So all of those, we say, impact in a negative way on the legal certainty that should be available for a prisoner and for the community as a whole as to how long an individual has to serve under a tariff.
Thank you.
We also then remark on the fact that this is this approach that there is specific provision made for the department to take into account circumstances of unlawful release is mirrored in other provisions in the 1953 Prison Act of Northern Ireland, and I'll just provide you with that reference for your note. That's at tab 15 MS 809. The relevance also of Article 6 is that we say that it helps to look at this question of what the definition should be as to the part of the sentence, and under Article 5.2, what the part of the sentence that has to be served is defined as being such part as the court considers appropriate to satisfy the requirements of retribution and deterrence. And that, you will recall, was why specific emphasis was placed on the fact that there was no consideration of these concepts of retribution or deterrence in the Good Friday Agreement, or indeed in the 98 Act. So really, the 98 Act, through its most unusual and extraordinary nature, stepped outside the conditions where there's usual considerations that retribution and deterrence is necessary in the discharge of a tariff. We also say that the concept of how to serve a sentence and the correct way of interpreting that, we say that Article 6.6 can be read in such a way that one can see that one can serve a sentence when unlawfully at large. So if that is the correct extrapolation from that provision, then one can clearly serve a sentence whether one is physically incarcerated or indeed outside the confines of the prison walls. And for that reason, then, we say that looking at Article 6.6, if one then looks back at Article 5.1, which deals with the release provisions, that it's clear that there's no presumption that serving a sentence requires the life prisoner to be in custody for the entirety of his tariff. That a life prisoner is always a life prisoner and excuse me, is always serving his sentence is clear from the other provisions in the order, to include Article 2.2 and Article 8.2 and 9.1 that deal with the post-release monitoring and licence conditions, and that the language used throughout the order shows that serving the sentence continues, and we're fortified in our view of how to interpret this statutory language by how it was interpreted in similar circumstances in two Northern Irish divisional court cases of relatively recent vintage, cases of Ree Williamson and Ree McConville. And in both of those cases, Williamson is found at page of the 4 volumes, page 499 at paragraph 21, and McConville is found at tab 407 at paragraph 28. What both of those decisions find was that the sentence and how a prisoner serves his sentence encompasses both the custodial and the licence period. Obviously, those arose in quite a different set of statutory provisions. It was in relation to the Criminal Justice Northern Ireland order, but we say that the sense of it can be read across into the 2001 order.
Sorry, what was the reference to Williamson?
Williamson is found at tab 3 of the core volumes, which is at page 499.
499, thank you. And McGonville?
That was found in the same core volume at tab 4, page 5.
Thank you.
Now, the next point that I'd like to address the court on relates to the absence of any express provisions as to how time spent on release on licence should be taken into account when calculating this tariff. And as I've already outlined, other than Article 6.6, there are no express provisions. And what we say to that, the relevance of that is that given that there's been no advance or explicit warning to life prisoners, we say that this realisation that this is how these sentencing instruments are to operate amounts to a very real detriment to him and could, of course, be categorised as doubtful penalisation. And what we say on that is that if one's liberty is to be imperilled in this way, that there has to be a very clear authority of law. And what this court will have to conclude is that what is to be inferred from the reading of these, the 2001 order and the 98 Act, and we say that if there is an inference to be drawn that it should tend against inflicting a penalty on the life prisoner. And we have, to that regard, referred the court to two authorities, which we say bear on this point, that the statutory intention should be very clearly spelt out if one's liberty is imperilled. And we refer firstly to the case of Hallstrom, which is found again in the core volume at tab 7, MS page 570. Hallstrom obviously was in the mental health arena, but we say that the canon of construction that was articulated by Mr. Justice McCullough remains nonetheless relevant to this situation. We've also referred to the case of B, a minor, which is found at tab 8 under page 614, in which Lord Nichols said that the interpretation of the statutory provision must be where it will interfere with an individual's liberty must be compellingly clear. We say it's important in the analysis of the 2001 order that there was no express provision made, either in that order or amendment of the 98 Act to address that. And that obviously could be viewed as one of two possible reasons. Either that there was no realisation of the potential problem, and the divisional court in their decision alerted to the fact that the speed with which the 98 Act was brought about, as well as the environment in which there was such controversy about the introduction of the Act. The alternative construction, of course, is that this issue was recognised, but the decision was made that there was no requirement for any express provision, because perhaps from a consideration which the department has been labouring under for some considerable time and has applied to other life prisoners, that read properly, the time spent on licence should properly be accounted to discharge the term of the tariff that was subsequently set with retrospective effect. We also say that the fact that the legislature has previously considered and implemented provisions relating to what can and cannot be counted in discharging a custodial sentence shows that it's really something that is on the landscape, as it were. And we point to the two provisions in the 1953 Prison Act, and they're found at tab 15 MS 801 and 809, and those are the provisions in section 24.4 of the Prison Act, which related to suspending a licence when temporarily discharged on foot of the prisoner's own conduct and making himself ill, and then the provision in section 38.2 could be seen as an analogue provision to that introduced by Article 6.6 of the 2001 order.
Yes, it's interesting to see how far back this provision, Article 6.6, or its analogue, goes. And this is the 53 Act. I just wondered from a footnote whether actually subsection 2 was introduced in 1961. So perhaps we can take it that it is 1961, unless you correct that.
No, I certainly don't.
Thank you.
I don't doubt that. So we say that by comparison with these provisions, it's submitted if it had been the intention of the legislature that time spent outside of the prison whilst on licence shouldn't have been counted, that should have been made compellingly clear. We move on to some of the remarks that I wish to make about the divisional court's decision. I certainly don't want to pick over minor areas of disagreement, but we do say that it perhaps strayed too far from the key statutory instruments, which we say are the interplay of the 98 Act and its importance in construing the 2001 order. We say that the exceptionality of the accelerated release scheme with the context of its overarching aim of securing peace in Northern Ireland, did not prioritise the importance of retribution and deterrence as were so clearly articulated in the 2001 Act. And it's for that reason that we contend that approaching the question of how life sentences should be considered requires a different approach to that when one is dealing with a conventional life prisoner who hasn't had the benefit of the 98 Act applied to him. The department clearly understood that the 30 years tariff ran from the point at which the prisoner was incarcerated, and this was applied irrespective of whether he was within the prison walls or not. Now, the divisional court's response to that was that it would provide the prisoner with an unmerited windfall, in that he would have had the benefit of the early release scheme but failed to adhere for the rest of his natural life to the licence requirements. And
Are you saying that this problem simply wouldn't arise in relation to an ordinary life prisoner outside the 98 Act because he wouldn't be allowed out on licence until his tariff was completed?
Yes.
Is that the point?
Well, I think that is the point, yes, that the 2001 order was constructed with the ordinary prisoner, the ordinary life prisoner, if we can call it that, in mind. It didn't seem to take into account the difficulties that would come about for those life prisoners who, certainly perhaps in 2001, it was hoped that they would never breach the terms of their licence, but we know that there was a cadre who did and who were returned on foot of their breach of their licences. And that's where we say the real problem emerges in this case, in trying to shoehorn the 2001 order onto the extraordinary scheme that was enacted by the 98 Act. And that's why importing, we say, concepts such as personal retribution and deterrence really don't fit, because they're out with the whole scheme of the 98 Act, precisely because of what it was trying to achieve. And there remain in Northern Ireland, as is evidenced in the core volume at page 396, at least 135 life prisoners who have, notwithstanding their release, they remain released on foot of the 98 Act, and who conceptually at least remain liable to, should they breach their licences and be recalled to prison, they too could find that, notwithstanding the passage of 20 years, they could find themselves back at the point of their tariff where they were when they were first released. And for someone who was convicted in terms very proximate to the introduction of the 98 Act, they would find themselves very easily at the start of a 20 or 30-year tariff. And perhaps that is the way that the Act is to be construed, but from one perspective, the fact that Mr. Stone adhered to his licence for his conditions for the 6 years could have important practical and political significance on the establishment of peace in Northern Ireland at the time. The question is, does any credit accrue to him for that? We say that the penalties that were set out in the 98 Act, namely the revocation and the return to prison, should be the only penalties that flow from, express penalties that flow from his breach. And we say that that is important in terms of legal certainty. I'm conscious of the time, and I'll perhaps just summarise some...
Yeah, you have 2 more minutes.
2 more minutes. In 2 minutes, without speaking very quickly, I would like to conclude and say that the Department submits that the correct interpretation of the relevant provision is that all of the time that is spent lawfully outside of prison pursuant to a licence should reduce the period that one has to spend on one's minimum tariff. And 6 brief points that I hope to make within the 2-minute time frame. Our core argument is that this derives from the intention of the 98 Act, that there was never any intention to give a difference in treatment to fixed term and life prisoners. The Good Friday Agreement itself was wholly extraordinary, irrespective of personal views of morality or questions of unjustified windfall. Such views have to be set aside in order to answer the question, because of the aim that the 98 Act was directed at. We place considerable emphasis, thirdly, on the fact that there are no express provisions in either statute that deal with the situation that arose in these appeals. We say that the absence of any express provision is an important indicator of legislative intent, especially given that it will have such an impact on curtailing the individual's liberty. And we pray and aid the principle of doubtful penalisation. Fourthly, we draw attention to the use of the language and the manner in which serving a sentence can be interpreted as including the life prisoner serving his sentence outside of the confines of the prison walls. Fifthly, any argument that his release under the 98 Act could be viewed as some sort of advance, we say, should be set aside because of the very different licence conditions under the 98 Act and the licence conditions that would be imposed under the 2001 order. And sixthly and finally, what we'd say in relation to the proposition that periods are deducted from the tariff, that will lead to general uncertainty. And we've discussed earlier the impact that could have on compassionate temporary release and very laudable aims such as rehabilitative pre-release. And for all of those reasons, my lady, my lords, we'd say that this appeal should be allowed.
Thank you very much indeed. Mr. McLean?
My lady, my lords, as you know, I appear with my learned friend Mr. McConkie for the second term, Mr. Stone, the prisoner whose eligibility to be considered for release on licence under the 2001 order is at issue in these proceedings. And it's worth keeping in mind in our submission that if Mr. Stone is successful, that will not obviously result in his release. All he seeks at the moment is the opportunity to have his case considered by the parole commissioners. Now, in terms of my submissions, I want to begin, if I may, by addressing the attorney's intervention and then making some further brief submissions on the substance of the appeals. The court will know that we filed reasonably full written submissions on each of those two topics already. And as you'll have seen, there is much by way of common case between our submissions and those of Ms Murnahan QC on behalf of the department, whose oral submissions I gratefully adopt insofar as they're consistent with our written case. So in light of that, I hope I can present my submissions succinctly. Dealing first then with the issue of whether this case is a criminal cause or matter, Lord Justice Gillen, in his report on the recent review of civil justice in Northern Ireland, said of the civil-criminal divide in this context, there's no reason to retain this distinction, which is complex and now anachronistic, and it should be abolished. And faced with the attorney's intervention in this appeal, I've even more sympathy for that view than I previously did. But my lady, my lords, the attorney's intervention is to the effect that the court has no jurisdiction to hear either appeal. And effectively, at a late stage in the proceedings, that all of the parties should be sent away, notwithstanding that none of the principal parties in the appeal would welcome the delay or additional cost to which that would give rise. So against that background, our approach to this issue is, as we've said in our written submissions, a pragmatic one, pragmatic in two senses. Firstly, we are eager, as indeed is Ms McGuinness to her credit, for the appeals to be heard and for this court to determine the issue of law of general public importance which has arisen. And secondly, because we ask the court to think very carefully about what it can and should do in the peculiar circumstances of this case and how the issue has arisen. And we respectfully urge the court to be extremely cautious about adopting the course proposed by the attorney in these proceedings at this stage, when the proceedings have the following salient features, and I want to give the court 4 features which we say are significant. First, as you will have seen, a very experienced divisional court in Northern Ireland determined that the case should be heard as a criminal case. And the court concluded Lord Justice McCuskey, as he now is, who had given an extensive written judgment for the majority in the most recent authoritative case on this issue in Northern Ireland. That's the JR27 case. Second, the same court proceeded to certify a question of law of general public importance under Section 41 of the Judicial Act. And it could obviously only do that if it remained of the view that this was actually a criminal cause or matter. And thirdly, and we place some emphasis on this, no party to these proceedings has exercised or sought to exercise any right of appeal against either of those steps or orders. So putting it very simply, we submit that there is no appeal before this court, nor was any appeal pursued to the Court of Appeal in Northern Ireland, assuming that that would have been the correct course for such an appeal, against the divisional court's finding that this case should be treated as a criminal case.
I suggest, Mr. Schofield, that this court has got to, of its own motion, consider whether it has jurisdiction to hear an appeal.
Well, my lady, I anticipated that the court might possibly take that view, and that's why we have, of course, dealt with the substance of the attorney's points. But I would just respectfully ask the court to reflect on whether the court has to do so and whether this is an appropriate case for the court to grapple with some of the thorny issues which the attorney's intervention potentially raises. As I've said, my lady, there is no appeal on the issue, and we say, therefore, that the starting point for the court's consideration should be that the approach taken by the divisional court is presumptively lawful and presumptively correct, and the court doesn't have, in our respectful submission, either a duty, or we might boldly go so far as to say a right, in the absence of an appeal on that issue, to look at the matter afresh.
But, Mr. Schofield, the curious feature is that the divisional court didn't find that it was a criminal cause or matter. It decided, quote, on a pragmatic basis to treat this as a criminal cause or matter. So, was it legitimate to proceed on that basis?
But it amounts, we say, to a finding that the case was and should be treated as a criminal cause or matter. The court will have seen that there were submissions on that from both the department and from Ms McGuinness, each urging the court to say that it was a criminal matter. There were fairly extensive written submissions on that. That was the approach which a very experienced court took, and they reaffirmed that approach whenever they certified the question for this court. They could have said at that stage, we've given our decision, the urgency has now evaporated, we'll sit back and we'll look at this more carefully, because it might be that you should be going to the Court of Appeal rather than seeking the certification of a question. The court didn't do that, and they could not have certified a question unless they took the view, as a matter of law, that that was the correct course.
So, I mean, I'm very sympathetic to what you're saying, if there's a legitimate way in which we could do what you want us to do, but is there?
Well, let me try and persuade your lordship of that. And as I've said to my Lady Hale, I'll come back and look at some of the substance of the attorney's objections, but we say that the starting point for the court should be that the divisional court made a decision which is not properly subject to appeal in this case. So the only question really for the court then is, starting from the baseline that this is a criminal case, whether my client, Mr. Stone, is a defendant who has a right of appeal under Section 41 of the Judicial Act. And we say that is a very simple question. We say that he plainly falls within the definition of that term in Section 41(6)(a)(1), namely, the person who was the defendant in the criminal proceedings with which these judicial review proceedings are in connection. And that we say is really the only point which the attorney is able to raise at this stage, if we take as the starting point that the case is a criminal case. But we say that particular issue can be disposed of very simply. Mr. Stone obviously was the defendant in the related criminal proceedings. And if you're with me on that, we do say that the further question of whether the department can maintain a separate appeal, either as a prosecutor or as a defendant, really becomes academic, because it's been permitted to intervene in the Stone appeal, and the court therefore has a competent appeal against the judgment and order of the divisional court before it. So in short, my lady, my lords, we say, with respect, and this is meant as no criticism of the attorney, but it's too late to open up the question of whether this is in fact a criminal case. That has been determined. The divisional court's orders in that regard are presumptively lawful. They haven't been properly challenged, and that should be the starting point. The only question is whether Mr. Stone is a defendant, and we say that's clearly to be answered in the affirmative. Now, if the court is against us on looking at it in that, what we would say is as a pragmatic way, then we make 5 short points on the substance of the attorney's submissions. Firstly, my lady, my lords, we say the recent authorities on this topic, including the decision of this court in Belhaj, consistently say that a broad approach should be taken to the question of what is a criminal cause or matter for the purpose of appeal rights. And we've set that out in our case on the attorney's intervention at paragraph 7. The attorney's approach, we submit, fails to take the broad approach which is required by the authorities. Secondly, we say that the attorney's approach places undue weight on the interpretative provisions in section 41.6 of the Judicial Act, or in England and Wales, the equivalent provisions in sections 1 and 17 of the Administration of Justice Act 1960. So again, that's contrary to the approach which has been taken and is now therefore required in previous authority, including in Belhaj, from which the attorney has not asked this court to depart.
Well, I think he came pretty close to it.
In his oral submission, certainly yes, my lady. But I'm not sure the case was quite set up in that way. But that really is where the attorney's submissions take the court. But in all of those previous authorities, the interpretative provisions in section 41.6, or the equivalent English provisions in the Administration of Justice Act, have not been thought to restrict the meaning of criminal cause or matter in section 41.1. We say that it would be inappropriate to have the definition of one particular term, the defendant or the prosecutor, essentially governing the meaning of the much broader term criminal cause or matter. The third point, my lady, my lords, is that the nub of what is between our submissions in this case and the attorneys we submit seems to resolve to whether these judicial review proceedings are in connection with proceedings for an offence under section 41.6 1A. Now, that statutory formulation, in connection with, we say, is a broad phrase. It encompasses a range of different nexuses or relationships between the judicial review on the one hand and the criminal proceedings on the other. And again, we say that authority suggests that it is to be given a wide rather than a narrow interpretation. So the court has already been taken to JR 27. It's in the second authorities volume at tab 23, MS 1021. I'm not going to ask the court to turn to this, but in paragraph 26 of that judgment, there's reference to another case which isn't in the bundle, Kuogi. I hope that's the right interpretation. But in that case, the Chief Justice, Lord Bingham, said that if the main substantive proceedings in question are criminal, proceedings ancillary or incidental thereto are similarly to be treated as criminal. That's subsequently been applied in Northern Ireland. It's called JR 14 by Mr. Justice Weatherup, and you'll see that referred to at paragraph 29 of JR 27. But more recently, in the McAtee case in the Court of Appeal in England and Wales, it approved and adopted Lord Escher's formulation from the Woodhall case that a criminal cause or matter encompassed any question with regard to criminal proceedings at whatever stage of the proceedings the question arises. You'll see that in our case on the intervention, paragraph 7, subpara D. So, insofar as the issue is whether these judicial review proceedings are in connection with proceedings for an offence, that phrase, in connection with, is also on its face a phrase with a wide interpretation, and that's how it's been approached in authority. The fourth point, my lady, my lords, such a nexus can still exist when the criminal proceedings have concluded, even if they have concluded quite some time ago. And that, we say, is entirely settled law. You'll see it in the Blandford Justice's case, in the McAtee case in particular, where it's emphasised, and in JR 27. Then the fifth point, my lady, my lords, is that there will be such a nexus in cases where there is a challenge to some aspect of the sentence. Now, that was essentially McAtee, but that includes in our submission where the question is, as a matter of construction of criminal or sentencing legislation, when the sentence will expire, or in this case, when the relevant part of the sentence is served. And I wanted to take the court just to JR 27. I think that's the only case I'm going to open on this aspect of the case. But if you'll turn to that, it's in the Second Authorities volume, tab 23. It commences at MS 1021. I wanted to take you to paragraph 46 of the dissenting opinion of the Lord Chief Justice. So the Chief Justice took a narrower approach to the question of what was or was not a criminal cause or matter in that particular case. But on his understanding, this case would still be a criminal case. So you'll see at paragraph 41, he says...
Which page is that?
I'm sorry, my lord, MS 1044 to begin with. Paragraph 41, he says a criminal case or matter can arise...
Could you just give us time?
I'm sorry, my lord.
If you want us to look at something, it's helpful. So paragraph...
41.
Thank you.
He says there, a criminal cause or matter can arise, 1, before criminal proceedings are issued, 2, while they are pending, and 3, after such proceedings have arrived in an outcome. And he gives some example of each of those cases, but in paragraph 46, on the next page, you'll see the third category of cases is that in which the challenge is launched after the determination of the investigation or proceedings. Those cases in which there is a challenge concerning the number of days that the applicant has to serve in custody as a result of the sentence imposed are obvious examples. The issue in such cases is the meaning of the sentence passed. That's the summary that my Lady Hale put to my learned friend, Ms. Murnaghan, as to the submission that she was making, and we respectfully agree with both that summary and my learned friend's submission.
So is this case about the meaning of the sentence or the administrative working out of a sentence which has no dubious meaning?
Well, my lord, it's not, as we've said in our written submissions, it's not the case of pure arithmetic where someone's added up the numbers wrong. It is a case which is about construction of the 2001 order. And certainly as the Divisional Court has decided the case, it's a case about what Lord Justice McCluskey calls the DNA of the life sentence. It's about what the sentence means. It's about how the sentence operates. So we would say it falls within the category of cases identified by the Lord Chief Justice here. And just again for the Court's note, that has been followed in Northern Ireland in a number of recent cases. One is called Williamson. That's at tab 3 of the authorities. That was a case about providing credit for remand time. That was dealt with by a divisional court. It was against the Northern Ireland Prison Service, who obviously wasn't the prosecutor in the case. The next tab, tab 4, McConville. That's another sentence calculation case. That's about unallocated remand time being used to reduce a licence period rather than the custodial period in a separate sentence. Again, dealt with by the divisional court, a case against the prison service, not against a prosecutor in the traditional sense. So they were cases as here, but importantly, unlike McGuinness number 3, about the interpretation and application of sentencing legislation in circumstances where the result will affect how long an individual prisoner must spend in prison or on licence. So, picking up on the point made to my learned friend, Ms. Murnaghan, by Lord Jones, this is perhaps not strictly a jeopardy case because there's no additional penalty, but it is certainly highly analogous to a jeopardy case because the outcome of the issue will or will not result in Mr. Stone potentially serving an additional 6 years of his sentence.
In a case like McConville, you're concerned with the calculation of the sentence having regard to the normal incidents of the matter, such as remand, I think it was remand time in McConville. I mean, here we're concerned with something quite extraneous, aren't we? Something supervening.
We would say that the nexus is still not broken. It's still an incident of the sentence. It's about what the sentence means and about how it operates. Of course, it's a different case from the remand time cases, but we say that this case is actually a case much more closely involved with the criminal law proper than those cases, because it's about what the sentence means, using the Lord Chief Justice's phrase. I'm not sure you can put it any higher than that, my Lord. But certainly that's the approach which has been taken by the Divisional Court in Northern Ireland. There's been a consistent line of authority which follows that. And on the attorney's case, of course, all of those cases, it seems, are wrongly decided. McAtee is wrongly decided. Belhaj is wrongly decided. And this court must look afresh at this whole area of jurisprudence and completely revamp the way in which the test has been applied. We say, going back to how I opened these submissions, the court might well wish to look at these issues in some future case, where it's a case in the appeal raised by the parties and a point has been taken at the appropriate time and is the subject of decisions of the lower courts. But we respectfully do say a late intervention of an appeal on this point for many of the principal parties is not, we say, the time or the place to do so. So if you begin by taking the starting point as we contend, that the determination of the court below hasn't been appealed on that issue, the case is a criminal case, the only question is whether my client is the defendant in the related criminal proceedings, and we say that admits of an obvious answer. We also say that that cannot be affected by the absence of a prosecutor in the case, in the traditional sense of that word, because you'll have seen that the closing words of section 41(6)(1) say that any reference to the prosecutor shall be construed accordingly. So that's to say it takes its meaning from the presence of a defendant in the case, and the presence of a defendant in the case, even going some way along the attorney's line of reasoning, is what is important. So for those reasons, my lady, my lords, we respectfully urge the court to hear and determine substantive issues, certainly in our appeal, but indeed in both appeals. Move on then to the substance of the appeals.
You don't get any help, do we, from Section 40 of the Constitutional Reform Act, which gives us power, subsection 4, to determine any question necessary to be determined for the purpose of doing justice in an appeal to it under any enactment.
I've had occasion to rely on that before when I was urging the court to take a rather expansive approach to its own powers. We've dealt with that in our written case on the intervention. I'm just trying to find the reference to that for your lordship. What we say about that is it can't assist the attorney if he's right that there is no appeal to begin with, perhaps a circular argument. But secondly, we say that it's designed to do justice between the parties in the appeal. Doing justice between the parties in the appeal, as we, and indeed Ms McGuinness, to her credit, agree, is by the court getting on and determining the issue rather than sending everyone back to the Court of Appeal with the additional time.
Your point is, here we all are on, there must be some sort of appeal. It is terribly unsatisfactory, this sort of issue, to be decided at this level when all the parties have proceeded on a particular basis. And
I make clear again, no criticism of the attorney. This issue came to his attention late. This isn't the case to have this debate in our submission. If the court can avoid it, which it can in our submission.
there must be optimism on my part.
The lordship surely shouldn't be criticised for that. The substance of the appeal then, my lords, my ladies, so hopefully I can take this briefly. There is a very high degree of overlap between our submissions and those of the department. The central difference between us, and it's perhaps more a difference of emphasis than anything else, is that I think we place greater reliance on the 2001 order and approach it as the key provision, whereas I think my learned friend said that her core submission related to the 1998 Act. But in terms of the submissions on each of them, we're very much at EDEM. So why do we say that the provisions of the 2001 order are so important? Well, firstly, because it's a phrase within that order which is at the centre of this case. It's a phrase within that order which the court is called upon to construe and apply. The key statutory phrase, as the court knows, is whether Mr. Stone has served the relevant part of his sentence within the meaning of Article 6, paragraph 3A of the 2001 order. And in our submission, it's helpful for the court to bear that language in mind, rather than importing terms such as the penal term, which is used by the Divisional Court in paragraph 6. And that's because, as we hope that we've demonstrated in paragraphs 10 to 13 of our printed case, and as my learned friend Ms Murnaghan has submitted, the words serve and sentence are not loaded terms. They're used flexibly within the 2001 order, and it's plain from how that order is constructed that a life prisoner is still serving his sentence or her sentence even when released on licence under that order. So that's important, we say, to bear in mind. The second reason why we say the 2001 order is really the entry point for the court's consideration of this issue is because it is both a later provision than the 1998 Act, and it also deals specifically with the question of when time spent at large will be disallowed as against expiry of a tariff. That, of course, is the very question which the court has to address. So in our submission, there is no need really to go beyond the four corners of the 2001 order. Can I also make a slightly technical point, and I'm conscious that I'm going to refer to a provision here that the court doesn't have, but we can provide it if necessary. Insofar as there was any conflict between the 1998 Act and the 2001 order on this issue, which there isn't for reasons that we'll come on to, but insofar as there was, the provisions of the 2001 order, we say, would prevail. It's later and more specific, and even though it is a provision of subordinate legislation, the enabling power is Section 85 of the Northern Ireland Act. And you'll see that in the introductory text of the 2001 order, which is at MS 771. Now, Section 85 of the Northern Ireland Act is a provision that you don't have. That permits Her Majesty to make orders in council in relation to reserved matters, which at this time included the criminal law in Northern Ireland. But that does allow such an order in council to amend or repeal any provision made by an Act of Parliament. So, just for the court's note, we're not in the territory here where any conflict between the two provisions must necessarily be resolved in favour of the Westminster Act. So I wanted to turn then to Article 6, Subpara 6 of the 2001 order. As the court will know from our written case, we place considerable emphasis on that, and it's in the authorities at tab 14, MS 775. You'll also find it in our written case. If we can ask you to turn to that at MS 202. And we've set Article 6 out just at the very top of MS 203.
Well, this is the unlawfully at large provision,
Yes,
isn't it?
absolutely, my lady. And
the simple point is that it makes express provision for when somebody is unlawfully at large, thus implying that if you're lawfully at large, it still counts.
Absolutely, my lady.
As simple as that, isn't it?
Well, it is. We've probably overcomplicated it then, because you'll see in paragraph 15 of our written case, we've broken essentially that 1 point down into 4 points, but they all point in exactly the same direction.
Mr. Scoffield, do you think after the short adjournment you could show us how the Divisional Court dealt with the article?
I'll do that, my lord. What I don't want to do is repeat the excellent submissions made on this by my learned friend Ms Murnaghan, which we adopt. So perhaps after lunch, I'll perhaps spend some of my remaining time on looking at how the Divisional Court and how my learned friend Mr Lavery come at this point.
Thank you.
And that's perhaps an appropriate cliffhanger to...
Thank you very much indeed, Mr. Schofield. We'll look forward to hearing you do just that at 2 o'clock.